Hi, this is Judge Herb Dodell. Some of the things I like to do on the show is talk about technical terms, but put them in layman's terms so that it's understood. There's something you have all heard if you watch any lawyer shows on television, and that's something called hearsay. What is hearsay? I can also tell you that many judges never really understand the rule. It's one of the bedrock of rules of evidence. And basically, it's an out-of-court statement or conduct that's being offered at the trial for the truth of the matter when the person who either said it or did it is not available because they can't be cross-examined. And that's the reason why many times, you'll hear the objection, hearsay, and the judge will usually say sustained. But the important thing to recognize, and it's important when you're picking a lawyer to determine what their credibility may be and their understanding of the law, is that there's probably, I'd say between 30 and 40 exceptions to the hearsay rule, meaning it gets in, even though it's an out-of-court statement. For example, in restraining order cases, and I presided over that subject for about 5 years, hearsay is admissible, even though there's no cross-examination. In fact, the way it comes in often is in a report, a police report, a report from a doctor. Nobody's there to be cross-examined, but it comes in. And in small claims court, one of the bases for going to small claims court is that the rules of evidence are substantially relaxed, and hearsay comes in. Let me give you a couple examples of the exceptions to the hearsay rule. This is not to be all-inclusive. Again, we have very short periods of time to talk, and I can just give you kind of the tip of the iceberg, so to speak. But if you want to know more, the information is easily available and accessible. Now, there's something called the business records exception. In other words, if you've got a document that you want to offer into evidence, even though you don't have the person who prepared the document, if you can establish what's called a foundation, like building a house, you have to have a foundation. If you could establish that that document was prepared in the normal and ordinary course of business by the person who recorded it, and it was true and accurate at the time that the event took place, it comes in if it's authenticated, meaning you can prove that it meets all of these foundational requirements. It comes into evidence in the same form as any other piece of evidence, and it covers the particular exception. Also, there's something called an admission. Let's say you give a deposition, and now you've been arrested in a criminal case, and somebody wants to use that deposition transcript. Well, if you said something in that deposition that represents an admission of any kind of liability or could be interpreted as an admission, it comes in whether you testify in the criminal case or not. And we're going to talk about the Fifth Amendment when we get a chance, and why you generally do not, as a trial lawyer, put on your client in a criminal case. You have no control over it in a civil case, but you sure do in a criminal case, and rarely do I put on a defendant in a criminal case to testify. I'm going to explain to the reasons why when we talk about the Fifth Amendment, probably in the next show that we do. If you got any questions, get in touch with me. Ask Judge Herb at gmail.com, or you'll find it in the book, From the Trench to the Bench, Navigating the Legal System and Finding Your Spiritual Path Along the Way. Well, we'll see you next week.